Alright, hi everyone. Today, whenever you're watching this video, we're going to look at the last part of KK4 for Unit 4 Area Study 2, which are factors that affect the ability of courts to make law, the requirement of standing. It should be a short video today because there's not a lot to this part of the court. It is essentially the requirement that you must be affected by the matter in which you are currently presenting or pursuing through the courts. So, as far as lawmaking is concerned, part of this key knowledge is obviously looking at courts' ability to make law. And as we've previously stated, courts have to wait until a party actually initiates a claim before they can create a precedent. So therefore, they're very reactive, whereas, as we know, Parliament and the supreme lawmaking nature of it, they can be proactive. But so a party needs to pursue a case before a court can actually determine the case and then create a precedent. But a party cannot actually pursue a case in the court unless it has this thing called standing. So if you think back to the McBain case, so that was the case in which a doctor took Victoria or challenged Victorian legislation because it was inconsistent with federal legislation, because he could not actually service or provide a service to women in certain situations. So if you were not married, and you weren't a de facto, you could not have IVF services actually provided to you. He had standing because he couldn't provide the service to these women, so therefore he had standing to actually challenge the validity of that law in court. So that's essentially what standing is. He was directly affected by those particular laws. Okay, so the ability of that should be a party. The ability of a party involved in a case to demonstrate to the court there is sufficient connection to the issue, legal and factual, to support the party's involvement of the case. You have to demonstrate that you have standing before a court will actually hear, or that is a determinant. That will generally be an initial issue in which, if it was an issue, say for instance the defendant would challenge whether the plaintiff has standing. So you have to demonstrate that you have sufficient connection, legal and factual, to warrant your involvement in the case. So basically the reason for standing is that you and I can't challenge the validity of a law just because we think it's wrong. We have to show actually a connection to that case. So that will obviously deter people who aren't genuinely affected by it and save the court's time, taxpayers, money, all that type of thing. Frivolous actions and a waste of resources, you have to have standing in some way. You just can't challenge a law because you think it's silly, even though that's what your contact with members of parliament's for. They are the supreme lawmaking body. If you have an issue with the law which you think is inappropriate, out of touch, whatever it might be, you don't bring an action in court, you take it up with the member of parliament. That's the way the system works. So High Court. You have to have, in the High Court cases, you actually have to have a special interest. So you need to demonstrate that you are more affected than other members of the general public. You have to actually show that you will gain a greater material advantage by winning or suffer a greater material disadvantage when you lose a case than just the average member of the public. So to have standing in a High Court matter is really, really difficult and hard to prove. So the bar is actually quite high. The downside of the requirement of standing is that plaintiffs who have a general interest in the case on behalf of another person or in the interest of the general public can't bring the matter to court. Say, for instance, you've exhausted your avenues of contact with your local member of parliament, the member for Nichols. What might actually happen is you think, okay, well, I'm going to take this matter to court. Unless you have standing, you have no avenue to actually take up this matter through the courts to challenge the validity of either the validity of the law or just the nature of the law itself. Or if you have to have that interest. So once you have spoken to your member of parliament, there's very little options for going through the courts. You still have to go a different way. You can't then bring a matter just because on behalf of someone else. That person has to have standing. If that person has standing, then it's their matter to pursue, not yours, no matter how well-intentioned you are. The case in point, which would be worth reading for you guys, is Kosborski in the state of Queensland, 2014. So they launched a test case in the High Court on behalf of 17 outlawed motorcycle clubs, and it was to challenge the constitutional validity of anti-biking laws, which had been introduced in 2013. Kosborski believed that a range of laws breach basic human rights, such as the freedom of movement and association, and they're obviously introduced by, and other governments have done it, to try and combat criminal organisations who commit serious crimes. And the theory goes that those not in large part, but bikie gangs do actually take part in such activities. The laws aim to make it difficult for declared criminal organisations, which included, as you can imagine, 25 different bikie clubs, from actually recruiting new members by banning 3 or more individuals to meet in a public place. So it does smell like a restriction on your freedom of association, your freedom of movement. Kosborski actually lost his case because the High Court refused to make a ruling on the grounds that he didn't have standing and had no right to challenge. Kosborski had not been charged with any crimes under the laws, therefore he had no special interest in the subject matter, so the court couldn't rule on whether the laws breached his legal rights because he didn't have standing. So the court was silent on the issue of whether it did actually breach the rights, because they didn't have to determine that, because Kosborski did not have standing to actually challenge the laws. So it did actually mean that another person who had standing or had been charged with the laws would actually be deemed to have standing. It did demonstrate how difficult it can actually be when someone's basic human rights, such as freedom of movement, freedom of association, has actually been breached. It is actually quite difficult to challenge that. The other case, in reference to McBain, bishops brought an action in the court based on the ruling was against their religious beliefs, so it gave single women the opportunity to access IVF. The bishops didn't have standing as far as the High Court was concerned. They had no legal, financial, or special interest in the case. Winning the case would not result in the bishops having a material advantage, so therefore they just had a dissatisfaction. They didn't like the laws. But again, that's what members of Parliament are for. You have an issue with the law, you take it up with them. So here's your summary. Requirement of standing only brought by people who are affected by the issue. You need to seek another, and if you don't have standing, you have to seek another means. If you've got a general interest in the case, bad luck, and the courts are still waiting upon that case to actually be brought before they can make a decision on it. So there are the tasks. Again, relatively straightforward for this particular part, and that ends Key Knowledge 4.